Good afternoon, Your Honors. We are here today because the defendant did this. Not just to Pitt, the dog he's accused of attacking, but to Goldie, his own hunting dog, whom he ordered to attack her. Because he enjoyed the thrill of the hunt, and because he never saw Pitt as anything other than a hunting target, he ordered his obedient dog to attack his next-door neighbor's pet. And that is how he engaged in the crime of animal fighting. Now, please understand that the state does not question his pursuing lawful animals for the thrill of a hunt. He's allowed to do that under the law. There are certain kinds of animals that he can take his dog out to hunt for his entertainment. But the second that he expanded his list of targets to include his next-door neighbor's pet, he crossed the line from lawful hunting into engaging in animal fighting. The crime of engaging in animal fighting requires you to find that the defendant knowingly promoted, conducted, participated in, or performed any service in furtherance of an exhibition of animal fighting, which is in turn defined as a private or public display of animal combat in which the maiming or injuring of animals is a significant component for entertainment or gain. This was for the thrill. And when you break down those elements, the evidence clearly shows that the defendant is guilty of the crime of engaging in animal fighting.
Counsel, we know that Pitt came from a fighting house. What evidence do we have that Pitt was not the initial aggressor?
Well, more importantly, Your Honor, there's more evidence that Pitt was not an aggressive dog. Pitt came from a fighting household, from a fighting situation, and you heard testimony from Officer Carla Danger that that animals who do come from fighting situations can be aggressive. But what's important about this individual dog is that the only person you heard from who actually knew Pitt is Mrs. Pawson. She was the one who spent time with him for 4 months after taking him home, and she described him as a gentle creature. Even Mikey Jr., who attempted to get to know Pitt on a couple of occasions, said that he always behaved scared, timid, and there had never been any complaints. So while in general, one might be able to say that sometimes animals that come from fighting households end up displaying aggression, this dog, there's no evidence that he ever did.
Could we infer that he may have been dangerous because he was characterized as unadoptable?
The shelter where he was has a policy of characterizing any fighting dogs as unadoptable. So they don't go, and it would be difficult, certainly, to try to analyze every single dog that's brought in from one of those situations. In addition, adoptability is based in great deal on the perceptions of the public. And as, once again, Officer Danger told you, there is a stereotype of pit bulls and of dogs coming from fighting circumstances as aggressive, but that's not always true, as Officer Danger told you. And this particular dog was shown after Ms. Pawson took him home to be, to not display those characteristics.
Thank you.
So we know that the defendant enjoyed the thrill of a hunt. And we know this because he told you so. We know this because his friend, Charlie Hirsch, told you that when they went hunting together, that the defendant would get excited, that the defendant would do his whistle orders to Goldie, that she would obey them, and that he would then, as Goldie was going in for the kill, get excited, pump his fist in celebration, get red in the face, and cheer on the situation.
Counsel, but would you concede that there's no evidence that the defendant ever engaged in dogfighting before he was he was awarded some sort of commendation for defending law enforcement animals. He clearly has a bond with Goldie, so why would he all of a sudden put the dog that he cares for at such enormous risk? I mean, what's the motivation for him doing that? As you point out, the dog is badly injured.
Yes, it's true that he never engaged, as far as we know, in dog fighting before. And he loved Goldie, absolutely. We don't deny that. And he has done work with the police officer to protect police dogs. That shows how he sees the animals involved in kind of two separate categories. There's the dogs that he thinks have value. Goldie, his hunting dog, the police dogs. And then there are the animals that he thinks of as targets, birds, rabbits, and Mrs. Possum's pit bull. The day that she brought him home, he said that Pitt was a fighting dog, that there was something that needed to be done about this dog. He posted online the week before this terrible incident occurred that he had a pit problem, and did anyone know how to hunt a dangerous dog, or did anyone have tips on hunting a dangerous dog? So that shows how he separated the categories. As far as his concern about Goldie's injuries, Mikey Jr. told you that when he was complaining, when the defendant was complaining about Pitt's very existence next door, that the defendant said Goldie could take that mud. So he may not have believed that Pitt could hurt Goldie this much. He may have believed that it would just be a situation of Goldie getting the prey and conquering the prey, as he had seen her do so many times before.
Why should we, go ahead.
But Mikey's a two-time convicted felon. Why should we believe a word he says?
It's true that Mikey has gotten into some trouble. Mikey, when he was barely a teenager, got involved in a couple of incidents with the law. At that time, he had grown up in a household watching his parents argue. He had just seen his mother leave, so he may have been acting out in that period of time. But in the last 4 years since that occurred, he has not gotten in any more trouble. He's gotten himself together, and he's working on pursuing a career as a nurse. So he is taking steps forward to improve himself. So the questions that the defendant attempted to cast on his credibility are really based on a couple of incidents that took place when he was 13 years old, and do not take into consideration all the strides that he's made since then. Furthermore, if you're not sure whether to believe Mikey, you can look at what Goldie herself did. Goldie, remember, is a well-trained hunting dog. She has been working with the defendant since she was a puppy. She has gone with him on hunts. She has always obeyed her commands. She knows her commands. And Mikey told you exactly what happened that day. Two short whistles to get ready and identify the target, and one long whistle to attack. And Mikey heard the defendant give those calls. So when you look at what Goldie herself did, either she disregarded the calls despite her excellent training as a hunting dog, despite the fact that she had always responded to those calls before, and just went off on her own, just long enough for the attack to occur. Additionally, consider the fact that when Mrs. Possum heard the fight taking place outside, and she went out to look, she saw the defendant cheering the dogs on. Essentially, she caught him in the act. And then what did he do? He blew the whistle to release, and Goldie released. So despite, as the defendant would have you believe, despite as the defendant would have you believe, previously ignoring his command to release, she obeyed it again moments later. So that makes you wonder which is more likely, that Goldie, who is a well-trained hunting dog, simply disregarded the commands of her owner with which she was terribly familiar, or that she actually followed his commands, and that Mikey was telling the truth, that those were the whistles that he blew.
Counsel, but you said what's more likely, and that may very well be, but isn't the state's burden here not just more likely or preponderance, but beyond reasonable doubt?
Certainly, and common sense and experience and weighing of all the evidence are all parts of that decision calculus. So when you consider that Mikey gave direct evidence, his testimony provided an eyewitness account of everything that took place that day, and he was the only one there. And that is corroborated by Goldie's behavior, by the fact that Mrs. Pawson saw the defendant engaged in behavior that was consistent with the behavior that he engaged in when he'd gone hunting with his friend in the past. All of that together adds up to guilt beyond a reasonable doubt.
Don't you think it's important, though, for us to consider whether or not Mikey heard the whistle, and there's not an agreement about whether or not it's audible to humans?
Well, the defendant did put a witness on the stand that asserted that it was, well, that initially asserted, I should say, was that the whistle was inaudible to humans. She was the inventor of the whistle. She has no training in sound engineering or in physics. And when she was questioned a little bit further, she was forced to admit that, yes, well, maybe he could have heard it, but he had to be standing close. Well, he was standing close. He was right there next to the defendant, and he was able to hear the whistle. As the inventor of the whistle told you, ultimately, inaudible was just marketing speak.
So if he was standing right next to his son, how could he be causing why would he put his son in imminent danger? Wouldn't he be in the same imminent danger as his son?
I'm sorry, I don't understand the question.
Well, for the third count to follow, the defendant has to knowingly put a minor, which Mikey admittedly is, in imminent danger. If when all this is going on, when he's giving the command supposedly to Goldie, if he is in the immediate proximity of his son, how does that follow that wouldn't he be putting himself in danger? That seems illogical.
I see what you mean. First of all, the count of endangering the welfare of a child doesn't just rest on whether Mikey was in imminent danger of being involved in the dog attack. Rather, that's directly related to the conspiracy count as well. So when the defendant made Mikey part of engaging in animal fighting by ordering him to use the video camera to film the fight, that essentially made him engage in a crime. And endangering the welfare of a child includes promoting or encouraging or causing a child to engage in a crime. So the
two alternate theories. So
Yes.
the state is essentially electing to go with the unlawful activity as opposed to imminent danger theory?
I wouldn't say that the state is choosing one or the other, but that they are both reasons. And in answer to your previous question, why would he endanger himself and his son? Again, he may not have thought that it would be anything other than Goldie attacking and conquering Pitt immediately. He may not have realized or thought that there was any danger to them because Goldie was just going to get the target as she always did before. The other thing that I want you to consider is the character of the individuals here, and not just the character of the defendant, but the character of these two dogs. We've talked a little bit about how everyone who knew Pitt, which is only one person that you heard from in this courtroom, described him as a gentle creature. He was Mrs. Pawson's cherished friend, a gentle companion to an elderly widow. And that's all anyone actually knew about him that can speak about Pitt directly. The defendant wants you to believe that Pitt acted out of character on this day by unprovokedly running after Goldie. Then there's Goldie. Goldie's character was as a well-trained, obedient hunting dog. The defendant wants you to believe that she acted out of character, she directly ignored commands, and that she went after Pitt without any instruction from him. And then in terms of the defendant's character, he tends to try to explain away a lot of his bad behavior, to say that things aren't really his fault. He didn't order Goldie to attack Pitt. She disobeyed her orders. He didn't brandish a rifle at his wife. He merely forgot it was in his hand while he was yelling at her. He didn't deserve any of the complaints that citizens made against him when he was a police officer. They were just people trying to get off easy. So it makes you wonder if he is responsible for anything at all, or if he believes he's responsible for anything at all. One thing he did tell you he was responsible for was his officer instincts, which kicked in, he said, when he saw the two animals going at each other, as he described it. What were those officer instincts? Did he try to stop the fight before it started? Did he try to call to Mrs. Pawson to bring her outside and to try to restrain Pitt? Did he try to restrain Goldie, either physically or by blowing his whistle commands? No, apparently, according to the defendant himself, his officer instincts were to tell his son to grab the video camera and film the whole thing for evidence. Now remember that Mikey told you...
Why would he flush his career and his reputation over this?
You mean by videotaping?
By videotaping or conducting this fight?
Well, he just didn't think about anything but the thrill of the hunt and getting at this target that he wanted to get. He's already retired from the police force, so there's not really a damage on his career that's possibly at stake. And he also has become a different person, as you heard him say, and as you heard his friend say, since his wife left. You know, thinking about consequences, thinking about the long-term effect of what he's doing, as opposed to that dog's a target, something needs to be done about that dog, I'm going to do something about that dog, I'm going to hunt that Pitt today, as he said to his son. I'm going to get that Pitt today, is what Mikey told you. He said to him that morning. And that was all that was on his mind. Before the sun even rose that day, on September 14th, 2013, the defendant told his son to get the video camera ready, which was unusual for them. They didn't typically videotape their warm-up performances. They typically didn't bring the video camera out until they were actually going out on the hunt. But the defendant told Mikey to get the video camera ready. And then...
It's unusual for them to bring the video on the hunt.
I'm sorry?
It wasn't uncommon for them to bring the video on the hunt.
Correct. It was not uncommon for them to bring the video on a hunt itself. It was uncommon for them to bring the video camera on the warm-ups, which just underscores the point that to the defendant that day, those warm-ups were a hunt of Pitt. And the law says that he can't do that. He can't target a next-door neighbor's dog as a hunting target. He can't bring somebody else into the fold, as he did with his son, by making him an unwitting, unintentional party to the conspiracy. And he can't endanger the welfare of a child by causing his son to engage in this crime or by putting him in danger.
But counsel, what are we to make of the fact that at least 3 of the witnesses for the state have major biases? We talked about Mikey Jr.'s bias. Ms. Danger talks about bagging a hunter in much the same way as you claim Mr. Elvidge claims about bagging the dog. And Ms. Pawson is gaga over her dog and sees it really as her child. So when we're evaluating the witness testimony and with the burden on the state, how do you reconcile that?
In terms of Mikey's testimony, it's true that, we talked about him getting in trouble. And we also talked about Mrs. Pawson and what she saw versus what she believed about her dog. So, for example, she absolutely, without a doubt, believes that there's no way her dog could have done anything. However, she also saw the defendant standing over the animals as they were fighting, cheering them on. That's a detail which, obviously you can weigh in terms of whether you believe it, but it seems unlikely that she'd make up that particular kind of detail which comports so specifically with information about the defendant that she didn't know. And as far as Ms. Danger, she may not like hunters, but she didn't testify as to anything that the defendant did. She testified as to first of all, that she had never gotten any complaints about Pitt, which is true, and which the defendant doesn't deny. She testified as to the general character of pit bulls as, not necessarily being automatically assumed to be aggressive. And so even if she didn't necessarily like hunters, that's what she said would not be reflective of any particular bias toward the defendant, and therefore you must find him guilty. Thank you.